So, hey everyone. I've been promising to cover this Freedman response to the widower of Travis Flores, Clement Ziori, who is representing himself as an individual and the estate of Travis Flores. So they've filed a complaint against Freedman as an individual and his law firm. I have covered that already, so I will put a link to that video in the description or in the comments. It's an interesting video. It's an interesting lawsuit. I did not like the complaint. I thought it was awful. I thought it felt a bit kind of like there was a bit of grifting going on. I'm trying not to be disrespectful at all, but I have covered the Travis Flores lawsuit in some depth, as much as I can get hold of the documents, especially in US state courts, and not always the easiest for me to get hold of. I'm not even a US citizen, so they're certainly not, as easy to get hold of as, Pacer and Court listener for the federal stuff. But what I have been able to get hold of the original case where Brian Freedman represented Travis Flores against Justin Baldoni, Wayfarer, and other parties, the conclusion was that there was no liability found for the copyright infringement that was originally alleged. And the case was dismissed voluntarily at Travis Flores's kind of request. So we actually have more information about what happened in the original case from this, which is really, really interesting to know and kind of makes more sense. So there's more context. And before we get into that, though, just really quickly, you'll notice, because this is the other thing that Freedman has done, you'll notice that if I just bring it up here, the case is assigned to the Honorable Brock T. Hammond. That's the judge. The other thing Freedman has filed, if I can get this to work, because it doesn't always work, is a challenge to judicial officer. And in that case, he has challenged the Honorable Brock T. Hammond. If we have a look here, at this, I can't highlight that. Right, so just under the box where it's ticked judge, I'm a party or attorney for a party to this action or special proceeding. The judicial officer named above, and you can see the judge's name, before whom the trial of or a hearing in this case is pending. They got a hearing pending for next month. Or to whom it is being assigned is prejudice against the party or his or her attorney, or the interest of the party or his or her attorney, so that the declarant cannot or believes that he or she cannot have a fair and impartial trial or hearing before the judicial officer. So what that is basically saying is that Freedman and or his firm does not believe that the judge is capable of being impartial, and that he is prejudiced against either Freedman as the individual or Freedman and or his firm. So that's like, I don't know why. I don't know what's happened. There must have been something must have happened previously to warrant Freedman. I'm going to say Freedman. I'm also talking about the law firm, to warrant Freedman having this belief. But he has actually challenged the judge. So that is also been filed. So if we go back, so this is an anti-SLAPP motion, and it's also a motion to strike. It is a whopping 438-page document that's been filed. However, much of this is nothing to do with this lawsuit directly. A lot of it is like the complaint, and first amended complaint from the Blake Lively lawsuit and various media articles talking about the Blake Lively lawsuit, and where they may have mentioned Freedman's the fact that Freedman previously represented Travis Flores against Justin Baldoni. But this motion is only 15 pages long, so it's not too long. Let's have a look. Okay. To the Honourable Court, all parties and their counsel of record, please take notice that on May 6, 2026 at 8:30 a.m. or as soon thereafter as counsel may be heard in Department 31 of Los Angeles Superior Court, defendants Brian Freedman and LFTC, the Freedman defendants, will and hereby do move this court pursuant to California Code of Civil Procedure, Section 425.16, or the Anti-SLAPP statute, for an order striking in whole or in part and dismissing with prejudice and without leave to amend the complaint and each of the complaint's 5 causes of action for breach of contract, breach of fiduciary duty, legal malpractice, invasion of privacy, and defamation filed by Clement Suri. I don't know if I'm pronouncing his name right, so I'm just... if you followed my coverage of the Macron and Candace Owens case, you will know that I am not good with French names. Both individually and on behalf of the estate of Travis Michael Flores. Okay. This motion is made on the grounds that... that means so the hearing is actually May, not February. Right, that's my mistake. It's getting confused. Okay. This motion is made on the grounds that the complaint and each of its causes of action in whole or in part is subject to the Anti-SLAPP statute because it arises from the exercise of defendants' rights of free speech and petition and conduct in furtherance of those rights in connection with issues under consideration by a judicial and or other body and or other official body and issues of public interest. In particular, the complaint and each of its causes of action arise from defendant's speech and conduct in the context of litigation, including without limitation, speech and alleged speech to the public and the media about judicial proceedings and or matters and persons of public concern, including matters and issues about which the press and the public have demonstrated consistent interest. Therefore, the complaint and each cause of action, in whole or in part, falls within the scope of the Anti-SLAPP statute. Okay. Because the Anti-SLAPP statute applies to plaintiff's complaint and each of its 5 causes of action, the burden shifts to plaintiff to establish with admissible evidence a probability that he will prevail on his causes of action. Plaintiff cannot satisfy that burden. He cannot show that his claims are legally sufficient or that he can overcome defendant's defenses. Plaintiff's 5 causes of actions, or alternatively portions thereof, should be stricken for the following separate and independent reasons. The complaint and each of its causes of action, are barred in whole or in part because the allegedly actionable statements made to the public and media and conduct in furtherance thereof by defendants are privileged under 1. Civil Code Section 47D, and or 2. The 1st and 14th Amendments to the United States Constitution and Article 1, Section 2 of the California Constitution. The complaint's 5th cause of action for defamation is independently barred for additional reasons. A deceased person cannot be defamed. The estate of a deceased person cannot initiate a cause of action for defamation concerning the deceased. The allegedly defamatory statements were not of and concerning Flores, who is deceased. Sorry, the allegedly defamatory statements... No, you said that right. The allegedly defamatory statements were not of and concerning Flores, who is deceased, or Suri, who brings the defamation claim and alleges harm in his individual capacity and as the administrator of the estate of Flores, and did not state or reasonably imply anything defamatory about either of them. And the allegedly defamatory statements were were non-actionable statements of opinion that did not state or reasonably imply a statement of fact as a matter of law. The complaint's fourth cause of action for invasion of privacy is independently barred because plaintiff cannot invoke or initiate a claim as to a deceased's, i.e. Flores's, common law right to privacy. The allegedly actionable statements were not about Flores or Suri, who alleges harm in his individual capacity and as administrator of the estate of Flores. The allegedly actionable statements were not offensive to a reasonable person to the extent the privacy claim is for the alleged publication of private facts. It fails because the allegedly actionable statements were not private. They were newsworthy and not highly offensive to a reasonable person. And to the extent the privacy claim is for false light, it fails as superfluous, and for the same reasons the defamation claim fails. The complaint's first cause of action for breach of contract, second cause of action for breach of fiduciary duty, fourth cause of action for invasion of privacy, and fifth cause of action for defamation are barred in whole or in part because the allegedly actionable statements made to the public and media are privileged under Civil Code Section 47B. The complaint's causes of action for breach of contract, breach of fiduciary duty, and legal malpractice should be stricken, at least in part, because defendants did not represent Flores and Flores's former legal adversary, Justin Baldoni, at the same time. Defendant's subsequent representation of Justin Baldoni was not in the same or a substantially similar matter as the prior representation of Flores. Defendants did not disclose any confidential and or attorney-client privileged matter. Such claims are superfluous of and fail for the same reasons as the defamation claim, to the extent they are based on statements that allegedly harmed Flores's reputation, character, credibility, and memory. Defendants did not fail to maintain and convey records to plaintiff, and defendants did not represent Sioi. Okay. This motion is based on this notice, the attached memorandum of points and authorities, the declarations of Brian Freedman and Jeffrey Payne, with his exhibits 1 through 10 thereto. All pleadings and documents on file in this action, and such further evidence, argument, and judicially noticeable material as may be presented at the hearing on this motion. Defendants respectfully request that this court strike and dismiss in whole or alternatively in part plaintiff's complaint and each of its causes of action in whole or in part with prejudice and without leave to amend. Defendants also request that the court enter an award of attorney's fees and costs in their favour and against plaintiff as required by Code of Civil Procedure section, and is cut off. Section 425.1.16c. Right. Okay, so let's get past all the table of contents and everything. Okay, introduction. So this is where the interesting information is now going to come in. Brian Freedman and his law firm represented Travis Michael Flores from July 2021 to March 2022 in a copyright and idea submission lawsuit against actor and filmmaker Justin Baldoni and others. Flores's complaint in that case alleged that after Flores conveyed his script titled 3 Feet Distance to someone he learned was connected with Baldoni, Baldoni's film 5 Feet Apart took elements from Flores's script with resulting similarities between the two works. After Flores's complaint was filed in September 2021, the defendants in that case produced extensive evidence of the independent creation of 5 Feet Apart, none of which was available to Flores or Freedman before filing suit. Faced with this new evidence and a pending motion to dismiss, Flores agreed to a non-confidential walkaway settlement in March 2022, under which all parties denied liability. A non-confidential walkaway is that basically means there's no non-disclosure agreement in place. So Flores is free to say what he wants and talk about the case and any settlement as he wants. Quite often when there's some kind of settlement, there is an NDA signed as well, so it silences people from talking about the terms of settlement. Freedman never met or spoke with Baldoni during the time he represented Flores. Freedman first met Baldoni more than 2 years later, in December 2024, when Freedman began representing Baldoni in litigation against actress Blake Lively and others in connection with an entirely separate film, It Ends With Us, that had nothing to do with Flores or his prior dispute with Baldoni. Flores died in May 2024, more than 6 months before Freedman met Baldoni and started representing him, and more than 2 years after Freedman's representation of Flores ended. Flores' surviving spouse, Clement Ziori, filed this action in October 2025, alleging breach of contract, breach of fiduciary duty, legal malpractice, defamation, and invasion of privacy. This anti-SLAPP motion targets the claims and portions of claims arising from defendants' alleged statements and related conduct in connection with the highly publicized litigation between Lively and Baldoni over 2 years after Flores' case concluded. California's anti-SLAPP statute applies to the entire complaint before this court, and plaintiff cannot establish his burden to show that his claims have merit for multiple reasons. For example, estates may not bring defamation or privacy claims on behalf of the deceased. Freedman's statements to the press are protected by the fair report privilege, the litigation privilege, and because they contained no defamatory statement of verifiable fact about Flores or Ziori, and the entire complaint depends on the incorrect premise that defendants represented Flores and Baldoni at the same time, which they did not. The complaint and each of its causes of action should be stricken without leave to amend. And if you haven't listened to my video covering the complaint this is responding to, I was quite critical the whole way through. I did not like the suggestion that because Freedman's representing Baldoni now, he could not, that there's some kind of conflict of interest, which was what was being alleged. Well, Travis Flores has been deceased for some time before any litigation was initiated and before Freedman was retained. His lawsuit against Justin Baldoni settled years ago. So, they were ridiculous claims. And I think each claim, as you went through it and broke it down, I was just having none of it at all. And it looks like Freedman's not either. Okay, so Flores' copyright lawsuit against Baldoni and others. So this is now where Freedman goes into the history of the actual lawsuit, the original lawsuit itself. On July 8th, 2021, Flores signed an agreement with Freedman engaging Freedman and Tatelman, now LFTC, to represent him in connection with a dispute related to Ambry Genetics, Caleb Remington, an Ambry employee who was a consultant on 5 Feet Apart and also has cystic fibrosis himself. Wayfarer Entertainment, this is when they were Wayfarer Entertainment and not Wayfarer Studios. Justin Baldoni, CBS Films, and Lionsgate, arising from the theft of Flores' screenplay 3 Feet Distance in the development of the theatrical motion picture 5 Feet Apart. On December 1st, 2021, Flores, via counsel, filed a complaint against these individuals and entities alleging claims for copyright infringement, breach of contract, and interference with contract. The complaint, which attracted media attention, alleged that Flores wrote a screenplay titled 3 Feet Distance inspired by his life and struggles with cystic fibrosis, and alleged that Ambry Genetics, a company whose primary mission is to sell genetic testing, including for cystic fibrosis, expressed interest in the screenplay, and Flores sent a copy to several Ambry representatives, including defendant Caleb Remington. CBS Films announced in January 2017 that it had begun development of an untitled film from dependent Justin Baldoni, and his production company, Dependent Wayfarer Entertainment, about teens with cystic fibrosis. Baldoni's project, which had similarities to Flores' screenplay, became the film 5 Feet Apart, and Flores learned that Baldoni had consulted extensively about the content of 5 Feet Apart with Caleb Remington, one of the representatives of Ambry, to whom Flores sent the screenplay for 3 Feet Distance. After the filing of the Flores litigation, defendants in the Flores litigation produced documents in support of their position that Baldoni had independently created 5 Feet Apart. Notably, counsel for Ambry and counsel for Baldoni produced extensive documentation that was unavailable to Flores and Freedman before the Flores litigation was filed, showing that Flores' allegations of access and copying were incorrect. Ambry had not shared Flores' script with any third party, including Baldoni. Baldoni independently created 5 Feet Apart based on inspiration from Claire Wineland, another sufferer of cystic fibrosis. And Baldoni did not meet Remington until after the allegedly similar elements were already embodied in Baldoni's draft screenplay. Counsel for Baldoni in the Flores litigation also detailed Baldoni's charitable activities, including for those with cystic fibrosis. After multiple stipulations to extend the response deadline, and after providing time to review the evidence presented, Ambry moved to dismiss Flores' complaint for failure to state a claim. On March 9, 2022, Flores entered into a non-confidential settlement agreement with all of the defendants in the Flores' litigation to settle fully and completely any and all disputes between the parties. The lack of confidentiality was an important term because it did not silence Flores. The Flores settlement explained that the parties had determined it is in their best interest to resolve and settle all disputes, claims, or potential claims and disputes between and among them without any admission of liability. Okay. The Flores settlement did not result in any direct financial compensation to Flores, but all parties, including Ambry, agreed to waive any right they may have to seek to recover their fees, costs, or expenses in connection with the Flores litigation. So, Flores, confronted with this overwhelming evidence that Justin Baldoni did not steal anything or use any part of Flores' own script, what it sounds like has happened here, and there is some speculation without all the facts, but Flores then agreed to withdraw the claims. There was no liability admitted by any of the defendants. There was no non-disclosure, so Flores was free to talk about, his views and his feelings on this and the settlement as much as he wanted to. However, there was a settlement that did not result in any direct financial compensation to Flores, and there's wording in that, very specific wording, did not result in any direct financial compensation to Flores. That's a bit I would speculate, and if I was to say, what do I think happened there? I think that Flores may have requested, or the defendants offered, and it was accepted, to make a charitable donation to a cystic fibrosis related cause. That would be my best guess. Because Flores himself was a huge activist for cystic fibrosis charities. So was Justin Baldoni. And I think there may have been a bit of a meeting of the minds that, because obviously there's no loss to Flores. If conclusively, if it's proven beyond doubt that they have not used his material, then he has not been, he's not had his copyright infringed. So there is no loss for him to seek. There's no compensation due to him. But he may have negotiated, or it may have just been an offer that was put forward because of the nature of the defendants, that, well, we will make a donation to cystic fibrosis or some cause related to cystic fibrosis. That would be what I think may have happened. I do not know, unless there's something in this that exclusively tells me without any doubt. I don't know that for sure, but would bet some money on that. Okay. Consistent with the Flores settlement, Flores filed a stipulation to dismiss his complaint, and on March 29, 2022, the court granted the stipulation and dismissed Flores' case with prejudice, so he could not refile it. Flores passed away over 2 years later. Baldoni's entirely separate litigation with Lively over 2 years later. Freedman first spoke with Baldoni over 2 years after the Flores litigation was dismissed, and he was engaged by Baldoni in late December 2024. On December 31st, 2024, 2 years and 9 months after the Flores litigation was dismissed, actress Blake Lively sued Baldoni, Wayfarer, and others in federal court in New York, alleging sexual harassment, retaliation, breach of contract, emotional distress, and other claims related to the production of Baldoni's film It Ends With Us. 2 weeks later, Baldoni and Wayfarer, represented by defendants, filed a countersuit against Lively and others, alleging inter alia claims for extortion and defamation. So there we go. In late January 2025, just a few days after Baldoni filed his countersuit against Lively, multiple press outlets began reporting on the fact that Freedman had previously sued Baldoni on behalf of Flores in the Flores litigation. For example, US Weekly reported on January 23, 2025, that before representing Justin Baldoni in his ongoing legal battle with Blake Lively, attorney Brian Freedman found himself involved in a separate case involving the actor. The US Weekly article described and quoted pleadings from the Flores litigation, noting that Flores had sued Baldoni, 40, he's putting his age in there, for alleged copyright infringement and breach of contract. The article was later updated to include a comment from Freedman clarifying a previous lawsuit he had filed against Baldoni. And the Freedman comment was, "I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfarer or any other defendant's part." Freedman continued, "This only further confirmed to me that Justin and Wayfarer are exceedingly honorable and highly ethical." Freedman's statements to the media did not mention Flores and was not based on any information that Freedman had learned from Flores at the time. The Lively-Baldoni litigation is not at all similar to the Flores litigation. This action. On December 8th, 2025, plaintiff Clement Zioi, Flores' surviving spouse and administrator of Flores' estate, filed this action against Freedman and LFTC on behalf of himself and Flores' estate, alleging 1. Breach of contract, 2. Breach of fiduciary duty, 3. Legal malpractice, 4. Invasion of privacy, and 5. Defamation. Plaintiff contends that Freedman's statements to the media defending Baldoni and Wayfarer in the context of the Lively-Baldoni litigation breached defendants' professional obligations to Flores and amounted to an invasion of privacy and defamation. Okay. The anti-SLAPP statute applies to each cause of action. Resolution of an anti-SLAPP motion involves 2 steps. Under the first step, a court decides whether the defendant has made a threshold showing that the acts or acts of which the plaintiff complains were taken in furtherance of the defendant's right of petition or free speech. If the defendant satisfies step 1, then the burden shifts to the plaintiff to show a probability of success, and if this burden cannot be satisfied, the claim must be stricken in whole or in part. A portion of a cause of action may be stricken if it falls within anti-SLAPP protections. To satisfy the first step, defendants only need to show that the alleged conduct underlying plaintiff's cause of action fits one of the four categories spelled out in section 425.16, subdivision E. Here, plaintiff's causes of action fall within sections 425.16, E2, E3, and E4. Okay. There is a footnote here which I will read actually, which concerns a little bit further up. So the complaint also alleges that defendants breached their fiduciary and contractual duties to Flores and committed malpractice with an allegedly inadequate pre-suit investigation into the Flores litigation and advising Flores to settle his case. Such claims have no merit, but in any event are time-barred by the applicable one-year statute of limitations, which accrued with the court's dismissal of Flores's case on March 29th, 2022. Okay. Section 425.16E2 covers any written or oral statement or writing made in connection with an issue under consideration by or reviewed by a judicial body. Courts take an expansive view of what constitutes litigation-related activities within the scope of Section 425.16. The subsection applies to statements to persons who are not parties or potential parties to litigation. Under the plain language of Section 425.16, subdivision E1 and 2, as well as the case law interpreting those provisions, all communicative acts performed by attorneys as part of their representation of a client in a judicial proceeding are per se protected as petitioning activity by the Anti-SLAPP statute. The Anti-SLAPP statute applies to claims arising from statements by a client's former attorney that allegedly harm the former client. Broadly applying the Anti-SLAPP statute, as the court must under California civil procedure, the Anti-SLAPP statute also covers alleged conduct centered in defendant's role as counsel. Thus, even where alleged acts taken in the context of litigation are not communicative per se, they can still constitute conduct in furtherance of the exercise of the constitutional right of petition. Sorry, I have done 6 videos so far today, and I am seem to be losing the ability to speak. Right, okay. All of the allegations giving rise to the 5 causes of action stem from statements and conduct in connection with the Flores litigation and or the Lively Baldoni litigation. This includes Freedman's statements to the media in the context of the Lively Baldoni litigation, which fall under Section 425.16E2, even though made to persons who are not parties or potential parties to the litigation. Freedman's statements directly responded and contributed to multiple media reports published just after the Lively Baldoni litigation commenced. The articles specifically discussed the parties' allegations in the Flores litigation and in the Lively Baldoni litigation, and discussed the fact that Freedman had previously represented Flores adverse to Baldoni in the separate Flores litigation. All of the alleged statements and conduct in furtherance thereof were litigation-related communications and conduct within the ambit of sections 425.16E2 and E4. All of the causes of action also arise from speech on issues of public interest. Under sections 425.16E4 and E3, defendants must show that their speech and conduct underpinning a cause of action occurred in connection with an issue of public interest. Like the SLAPP statute itself, the question whether something is an issue of public interest must be construed broadly. An issue of public interest under the Anti-SLAPP statute is any issue in which the public is interested, and it need not be significant to be protected by the Anti-SLAPP statute. In determining whether an issue is a matter of public interest, courts consider whether the subject of the speech or activity was a person or entity in the public eye who could affect large numbers of people beyond the direct participants, and whether the activity occurred in the context of an ongoing controversy, dispute, or discussion. The public interest component has a two-part analysis. First, we ask what public issue or issue of public interest the speech in question implicates, a question we answer by looking to the content of the speech. Second, we ask what functional relationship exists between the speech and the public conversation about some matter of public interest. All of the causes of action allege harm from Freedman's public statements to the media, which concern persons and matters of public interest. There is a public interest in the discussion of persons in the public eye. People who, by their accomplishments, mode of living, professional standing, or calling, create a legitimate and widespread attention to their activities. Celebrity issues alone may implicate the public interest aspect of Section 425.16E4. Here, according to plaintiff's complaint, there are several people in the public eye, including Flores, a published writer and prominent figure in the rare disease disabilities community who was featured on a television series. Baldoni, an A-list actor, director, producer. Lively, an actress. I'm sorry. I got to give my flowers to Freedman here. Baldoni's an A-list actor. Lively's just an actress. And Freedman, who purportedly litigates almost all of his cases in the media spotlight. This is reinforced by media attention paid to each of those persons. The disputes and litigation underlying this matter are also matters of public interest. The Flores litigation, which involved a popular wide-release film, was a matter of public interest since the time it was filed in 2021. Also, the multiple media reports that plaintiff relies on in connection with the Lively Baldoni litigation readily confirm the intense public interest in that litigation, as Lively and Baldoni are both prominent celebrities embroiled in a heated legal dispute, which, as plaintiff puts it, excited a media storm and frenzy concerning a very high-profile public sexual harassment and defamation action. There is also public interest in Freedman's intersection with the Flores litigation and the separate Lively Baldoni litigation. With respect to the second part of the film on analysis, the functional relationship, the inquiry does not turn on a normative evaluation of the substance of the speech, and it is not the social utility of the speech at issue or the degree to which it is propelled the conversation in any particular direction that matters. Rather, what matters is whether a defendant, through public or private speech or conduct, participated in or furthered the discourse that makes an issue one of public interest. Freedman's statements to the media furthered the discourse about his representation of Baldoni in the Lively Baldoni litigation, while defending Baldoni's character, reputation, and credibility in the Lively Baldoni litigation, and also accurately explaining that Baldoni had admitted no liability in the Flores litigation. Okay. Plaintiff cannot satisfy his anti-SLAPP burden. Because defendants satisfy the first step of the anti-SLAPP analysis, the burden shifts to plaintiff to show a probability of prevailing on his claims. Under this second step, plaintiff must establish that the causes of action are both legally sufficient and factually substantiated. Plaintiff cannot satisfy this burden for multiple independent reasons, and each of his claims should be stricken in whole or in part without leave to amend. Privacy and defamation claims cannot be asserted by a decedent's estate. Plaintiff alleges that Freedman made multiple public statements to national media outlets about Flores after Mr. Flores's death that cast doubt on Mr. Flores's integrity, credibility, and character, thereby defaming Flores. This claim fails as a matter of long-standing, unambiguous, and well-established law. Defamation of a deceased person does not give rise to a civil right of action at common law in favor of the surviving spouse, family, or relatives. Plaintiff similarly alleges that Freedman posthumously violated Flores's right of privacy by disclosing private and confidential information to the media and by disparaging commentary after Mr. Flores's death. The invasion of privacy claim likewise fails as a matter of law because the right of privacy dies with the person and cannot be asserted by anyone other than the person whose privacy has been invaded, such as an heir. The defamation cause of action fails for additional reasons. First, plaintiff alleges that Freedman's allegedly defamatory statements to the media harmed both Flores and Ziori. But Freedman's statements were not about or of and concerning either Flores or Ziori, which is a requisite element of a defamation claim. Plaintiff complains about Freedman's statements that Baldoni did absolutely nothing wrong, that the Flores litigation resolved with no liability on Baldoni and Wayfarer's part, and his opinion that Justin Baldoni and Wayfarer are exceedingly honourable and highly ethical. Such statements were about Justin Baldoni and Wayfarer. No part of them referenced Flores or Ziori as individuals at all. Okay, footnote. Plaintiff Clement Ziori is defined in the complaint as both the spouse and administrator of Flores' estate, who brings this action on behalf of himself and the estate. The defamation cause of action alleges reputational harm to plaintiff and the estate, and alleges emotional distress to Flores' surviving family, i.e., Ziori is a defamation plaintiff in both his individual and representative capacities. Right, okay. Second, the court can and should determine as a matter of law that Freedman's statements did not imply anything defamatory about Flores or Ziori. The only reasonable understanding is that Freedman was saying that Baldoni is good and honest, not that Flores or Ziori, neither of whom Freedman mentioned, are or were bad or dishonest. Third, Freedman's comment about the Flores litigation ending without liability is protected as substantially true because it accurately recounted the non-confidential Flores settlement agreement's terms. Fourth, Freedman's views that Justin Baldoni and Wayfarer are exceedingly honourable and highly ethical and not liable are statements of protected opinion. The First Amendment bars defamation claims based on statements that cannot reasonably be interpreted as stating actual facts about an individual. Whether a statement is a verifiable factual assertion or non-verifiable and thus non-actionable is a question of law to be decided by the court by examining the context and language used. In context, Freedman was defending his client, Baldoni, against ongoing accusations levied by Lively and her allies in reference to the Lively-Baldoni litigation. Nothing about the context or language of Freedman's challenged comments stated or implied anything negative about Flores or anyone else, but even if Freedman's comments could somehow be construed as implying that Flores did something inappropriate or dishonest by bringing claims against Baldoni, which defendants do not concede and did not in any way intend, that implication would be protected, non-actionable opinion. The invasion of privacy cause of action also fails for additional reasons. To the extent plaintiff's privacy claim is for the alleged publication of private facts, it fails for the additional reason that the allegedly actionable statements did not reveal anything private or confidential. The Flores settlement was not confidential, and Freedman did not reveal any information that he received in confidence. Even if something were private about Freedman's statements, nothing was. A private facts claim fails here because his statements were newsworthy, as evidenced by the media coverage, and lack of newsworthiness is an element of the private facts taught. The claim further fails because summarizing the non-confidential Flores settlement would not, as a matter of law, be offensive and objectionable to the reasonable person. To the extent the privacy claim is for false light and, as here, based on the same allegations as a concurrent defamation claim, it is superfluous and must be dismissed. To the extent the privacy claim is meant to be invoked by Zuri individually, there is no allegation or basis for such a claim because none of the allegedly privacy-invading speech or conduct is about Zuri. The claims are circumscribed by the absolute fair report privilege. Civil Code Section 47D provides that a publication is absolutely privileged if it is a fair and true report in or a communication to a public journal of A, a judicial, or C, other public official proceeding, or D, anything said in the course thereof. Although the fair report privilege is typically invoked by news media defendants, it also protects those who communicate information to the media. When it applies, the privilege applies absolutely, meaning that the defendant's statements are absolutely privileged regardless of the defendant's motive for reporting them. Whether a publication falls within the scope of the privilege is a question of law for the court. Courts apply Section 47D broadly. Several cases have been decided under Section 47D and all permit a certain degree of flexibility, literary license in defining fair report. Section 47D allows defendants to report the general substance of the underlying proceedings or records. A defendant's report need only capture the gist or sting of what was in the records or proceedings, and even extends to interviews conducted after court proceedings were over. Each cause of action is based in whole or in part on Freedman's statements to the media in the context of defending Baldoni in the lively Baldoni litigation. Freedman fairly and accurately described the Flores settlement. The case was resolved without any liability on Justin's or Wayfarer or any other defendant's part. Each of the causes of action is therefore barred, at least in part, by the absolute fair report privilege. Okay. The litigation privilege bars liability for Freedman's statements to the media. Freedman's statements to the press in connection with the Baldoni lively litigation, referencing the prior Flores litigation, are also broadly protected from liability by Civil Code Section 47B's absolute litigation privilege. For well over a century, communications with some relation to judicial proceedings have been absolutely immune from tort liability by the privilege codified as Civil Code Section 47B. The privilege applies to statements 1. Made in the course of a judicial proceeding, 2. By litigants or other authorized participants, 3. That aim to achieve the litigation's objects, and 4. Have some logical connection or relation to the litigation. The privilege extends beyond court filings to conduct outside the courtroom and post-trial, even if no function of the court or its officers is involved. The court decides whether the privilege applies as a matter of law, and any doubt as to whether the privilege applies is resolved in favor of applying it. The privilege bars plaintiffs' claims as to Freedman's litigation-related communications. Freedman's statements to the public and media in defense of Baldoni, which serve in part or in toto to underpin each of plaintiffs' causes of action, relate to lively Baldoni litigation and summarize the result of the Flores litigation. Such statements cannot serve as the basis for any claim. Okay. The contract, fiduciary duty, and malpractice claims fail for other reasons. First, the complaint incorrectly assumes that defendants represented Flores and Baldoni at the same time. They did not. Flores retained Freedman on July 8, 2021, Flores' case was filed on September 1st, 2021 and dismissed on March 29th, 2022. Freedman first met and was engaged by Baldoni in December 2024, more than 2 years after Flores' case was dismissed in connection with litigation threatened and then brought by Lively related to the film It Ends With Us. Because Freedman never represented Flores and Baldoni at the same time, there was never a conflict of interest under the rule of professional conduct 1.7. Second, Freedman's subsequent representation of Baldoni was not in the same matter, nor is the Baldoni litigation, Lively Baldoni litigation, substantially related to the matter in which he represented Flores. Freedman represented Flores in a federal copyright and idea submission case related to the film 5 Feet Apart. By contrast, Freedman represents Baldoni in multiple disputes involving Lively and others related to events that took place during and after the production of an entirely different film, It Ends With Us. The two cases have nothing in common except Baldoni and his company Wayfarer are parties in each. Thus, Freedman's current representation of Baldoni does not present a conflict under Rule of Professional Conduct 1.9 either. Third, Freedman did not reveal any of Flores' confidential and/or attorney-client privileged information. Freedman's statement to the media that the Flores litigation was resolved without any liability on Justin's or Wayfarer or any of the defendants' part merely restated the no admission of liability provisions in the non-confidential Flores settlement. That statement and Freedman's opinions of Baldoni's character were also based on information that Freedman learned from his review of the materials produced by the defendants, not Flores, in the Flores litigation, including information about Baldoni's charity work. Freedman did not disclose anything to the public or media that he learned from Flores and therefore did not violate Rule of Professional Conduct 1.6, Business and Professions Code Section 6068, or California Evidence Code Section 953. Fourth, as with the privacy claim, because the contract, malpractice, and fiduciary duty claims are based in part on Freedman's alleged public statements about Flores' reputation and character, they are superfluous and fall within the defamation claim. Conclusion, the court should grant this motion in full with prejudice and without leave to amend. I'm not going to read the rest of that. I think that gives us enough information now. So we will see what happens with this. I'm really curious about it. I don't think Clemenziori is going to win. That's my opinion. I just don't think he's going to win. I think this response is bulletproof. And entirely right as well. I had so many problems with the complaint and its grounds for the complaint. It just made no sense. And when they were saying, well, Baldoni stole this work and, it was all based on Flores' work, it's public information that Justin Baldoni was the whole thing was written with inspiration to Claire Wineland, another cystic fibrosis sufferer who has passed away. And that is very public information. So I had a lot of problems with this. Yeah, I had a lot of problems with this. Okay, I'm going to leave it there. I may come back and do something separate with the exhibits. I'll see how much time I've got, but I might do that because I don't like to leave exhibits untouched. I'm not going to bother covering, the complaints and anything from the Lively case, because I have, covered that to death and back. We've now all read the complaint and counter complaints in those filings. So you don't need me to sit and reread it because it's now an exhibit in another lawsuit. But anything to do with the original Flores case, I may go back and read that. But we'll see, time permitting. All right, guys, thanks for your time and watching this. See you later.